Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And as always, I hope you're just having the best day. For today's decision, we turn our attention to a decision from the United States Supreme Court, the first one of this term, in the case of Acheson Hotels versus Laufer. This is a case dealing with the Americans with Disability Act. The Americans with Disability Act was landmark legislation that made businesses much more accessible to handicapped people, and it has been a massive success in that domain. The Americans with Disability Act, among other things, requires hotels to provide information about their disability accommodations because some hotels might not have them, particularly, of course, if they were built, a long time ago. So they're required to provide information about the disability accommodations they do or do not have. Laufer went to the website of the hotel she was interested in staying at in Maine, and it did not have this information, thus a violation of the Americans with Disability Act. The problem, at least in part, is that Laufer, while being disabled, is also a serial suer. She goes around and she just finds hotels somewhere that don't have the accurate information online. So she basically trolls. She trolls for them. She's looking for not compliance. So the record is fairly clear that she had no intention of staying at this hotel. She had no intention of staying there. She had no plans to go to the area. She was just looking for hotels that didn't have accurate information so she could sue. And then she did. And through a combination of various factors, including a change of hotel management and other factors, she dropped the lawsuit. But there were significant issues with this because it seemed that she might have been dropping the lawsuit merely because the hotel sought review in the Supreme Court. She only dropped suit after they filed the initial plea for certiorari. I think even only after they filed their brief, incidentally. So she had already, won at the court below, and they are, asking for cert, and they filed the brief, and that's when she dropped the case. And so there is kind of this issue in law where, you just can't voluntarily exit from a lawsuit necessarily because you could always bring it again, right? So we do have mechanisms in law to prevent you from doing that if we find that you're doing it for some sort of tactical advantage, right? If you're doing it merely to prevent the court from getting a review, we're going to say, screw you, you're in this whether you like it or not. Thus, we get to our attention to the case of Acheson versus Laufer, where we're discussing these issues as it relates to the Americans with Disability Act, things that Laufer did or did not do, and so forth and so on. Let's go ahead and get started with this. This is out of the Court of Appeals for the First Circuit because that's where Maine is. The court granted review in this case to consider whether Deborah Laufer has standing to sue hotels whose website failed to state whether they had accessible rooms for disability as required by the Americans with Disability Act, even if Laufer had no thought of staying at the hotel, much less booking a room, which is basically what I said in the introduction. After a lower court sanctioned her lawyer in an unrelated case, incidentally, but still, Laufer voluntarily dismissed her pending suits, including her actions against Acheson Hotels, and filed suggestion of mootness. She's like, well, there's nothing left to do because, I've dropped out of this thing. Thank you, Alan Parker, for the 20 gift memberships. All right. Anyways, so though Laufer's case is moot, the circuit split on the issue briefed and argued before the court is very much alive. So her case might be moot in some sense, but we might not care. If you're doing it for tactical advantage, we're not going to let you do that. We're not going to let you play games with the court jurisdiction like that. All right, so they say held. The case is vacated as moot. So they agree it is moot in the end. The court has authority to address jurisdictional concerns of mootness and standing in any order it chooses. Fair enough. So it can decide whichever issue it likes first. And while the court is sensitive to the hotel's concerns about litigants manipulating the court's jurisdiction, the court is not convinced that occurred here. So the majority opinion is the case is moot, go away. And we don't think that this is clear that she's manipulating the court, so we're not going to keep it for that reason. So, okay, let's see what they write. Justice Barrett delivers the opinion of the court. Deborah Laufer has sued hundreds of hotels whose websites fail to state whether they have rooms accessible to the disabled. As the sheer number of lawsuits suggests, she does not focus her efforts on hotels where she has any thought of staying, much less booking a room. Instead, Laufer systematically searches the web to find hotels that fail to provide accessibility information and sues to force compliance with the Americans with Disability Act. So yeah, she trolls. She trolls hard. Ordinarily, hotels settle the claims and pay her attorney's fees, but some have resisted, arguing Laufer is not injured by the absence of information about rooms she has no plan to reserve. Only plaintiffs who allege a concrete injury have standing to sue. Standing is always a relevant issue. Laufer, these hotels have argued, is suing to enforce the law rather than remedy her own harm, which we would typically call a private attorney general, when an individual has the right to bring a public complaint, just like a public official would, like a prosecutor or the government one. And there are some instances where that's possible. California, for its part, has made it very possible. They allow that in a much wider sense. The federal law has a few instances where that's true, but not very many. And your mileage may vary, of course, between other states. Laufer has single-handedly generated a circuit split. That's how prolific she is. She alone has gone conflicting decisions from multiple circuits. So she's active kind of everywhere. This is her shtick in life. The 2nd, 5th, and 10th circuits have held she lacks standing. The 1st, 4th, and 11th circuits have had she has it. We've got 6 court of appeals just dealing with this one woman. Great. We took this case from the 1st Circuit to resolve the split, okay? The hotel files a petition. Laufer supports the grant. After we granted review, and so it was even later than I thought that she dismissed it. So it was after they granted review. So it wasn't even after they filed the writ. It wasn't even after they filed the brief. It was after the Supreme Court granted cert. That's when she wants to drop out of the case. The timing is pretty suspicious, my friends. The District Court for the District of Maryland suspended her lawyer for a practice of law for defrauding hotels by lying in petitions and during negotiation settlements. That case didn't concern her, but her lawyer was involved in similar cases, as one expects. It's not unusual to specialize. So her lawyer got called out in one of these cases by a different person somehow. There are, in fact, other people for, lying and defrauding and so forth and so on. So things were not looking great for him. It based the suspension on a report finding that person demanded $10,000 in attorney's fees per case, even though he used boilerplate complaints. So, not so much on the attorney's fees because you didn't generate new fees because you're using the same complaints. So the fees obviously would be much less because they didn't have to write the same thing. Okay. In addition, they funneled 6-figure sums to the father of a Laufer's grandchild for investigatory work that he never performed. So that seems like some shady shit. Making matters still worse, the sanctions order against the attorney also implicated the former counsel of record before the court. So not going great. And then they note that the 4th Circuit vacated and remanded the order, holding the district court gave insufficient notice. Disciplinary proceedings therefore remain pending in the district court. I'm sure it's not going to end well for him. So they didn't give him enough due process. Go back and try again, but the writing's on the wall, my friend. The writing's on the wall. Following these revelations, Laufer voluntarily dismissed her pending suits with prejudice, including her complaint against the hotel in the District of Maine. She then also, by the way, ran over to the 10th Circuit, by the way, and basically she filed a motion to vacate the decision that was in her favor, which is fun and exciting, right? So she panic ran over the 10th Circuit and said, hey, will you vacate the decision you decided for me? Because if you do, then there will no longer be a circuit split. Dutch. So she might be playing games, people. At this point, the hotel had already filed its brief, and we deferred decision on mootness because we might be saying this is an exception to mootness. There are a couple. This might be one. You're jerking us around, basically, and we don't like that very much. Laufer does not argue we must dismiss her suit for mootness. She acknowledges we can address jurisdictional issues in the order we choose, because we're the Supreme Court, of course, and so have authority to resolve the standing issue. But mootness is easy and standing is hard. She urges us to refrain from resolving the difficult question in a case that's otherwise over. So the Supreme Court can, of course, choose to decide either one. They can choose to decide both. It's up to them of how they want to handle it. So both are presented. And Laufer's like, hey, take the easy way out. Mootness? Mootness? Because I don't want you to reach the standing issue. Because if you reach the standing issue, all my cases and my entire shtick disappear. Right? If you rule I don't have standing, then I don't have standing anywhere. And all that stuff goes poof. And I can't get more monies. And that will make me sad. The hotel, on the other hand, stresses the difficult standing issue as the reason we took the case. Though her case is dead, the circuit split is alive. This court has received briefs and heard oral arguments. For efficiency's sake, the hotel insists we should settle the issue now rather than repeating the work later. Moreover, the hotel works if we dismiss this case for mootness, the standing issue might not come back anytime soon, particularly because one would imagine that other people might do the same trick of dismissing their case at the last minute, thus potentially denying the Supreme Court review perpetually. So there's that. Moreover, while Laufer has disavowed the intention to file any more ADA tester suits, so she says, I'm not going to do this anymore, I promise. Others will file in circuits that side with her, presumably, and hotels will settle regardless, as is pointless to challenge circuit precedent in this court. Why would any held take this case this far if the respondent can evade review by abandoning their claim? Right. So they have binding circuit precedent in the circuits where they do. That binding circuit precedent can only be overturned by the entire circuit sitting en banc or the U.S. Supreme Court. And why would any hotel go through all the trouble of, losing at trial because they're doomed, losing on appeal because they're doomed, with the hope of getting to the U.S. Supreme Court when they know that, it's not going to go anywhere? So that's a pretty good question. We are sensitive to the concerns about litigants manipulating the jurisdiction of the court, as you should be. We are not convinced, however, that they abandon the case in an effort to evade review. Okay, so they say on balance, not so much. All right. She voluntarily dismissed her suit after a lower court sanctioned her lawyer. She represents the court shall not file others. The case against the hotel is moot, and we dismiss it on that ground. But we might emphasize it in a future case. So maybe somewhere, sometime, some hotel will convince us to do it. I'm not sure why we're not doing it now, to be honest. Now seems like a good time to answer the question. Screw you. Let's do it anyway. But okay. So the judgment is therefore vacated, with instructions to the First Circuit to also dismiss the case as moot. It's moot all the way around. So the First Circuit precedent disappears because the case is moot. So as it's not binding precedent, it is now merely informative precedent. So, it's what a case somewhere someone held. So in a future case in the First Circuit, they could disagree without going to en banc because the precedent is no longer binding in that circuit. So I suppose that's nice. Justice Jackson objects to this position, urging us instead to leave the First Circuit judgment in place. And they cite the Munsingware practice, which is basically essentially this. This is the case on point, is Munsingware. Munsingware speaks to exactly this issue about manipulation of jurisdictions and it speaks a lot about what happens when cases are dismissed as moot. It speaks to this issue and, basically that you moot everything along the way. So it moots it basically from square one. Because it destroys all the precedent. So that's one of the things they deal. And also deals with issues resolving this. So that is the order of the court. It's only a short order, but we will read the further opinions because I'm interested in what other justices have to say on this issue, because I'm somewhat inclined to disagree with the majority on this issue, but I'm interested to see what they have. Justice Thomas concurs. saying Dauber Laufer has filed hundreds of lawsuits against hotels she has no intention of visiting, claiming their websites lack accessibility information mandated by federal regulation. At both parties' requests, this court agreed to hear the question that has divided the Court of Appeals: whether plaintiffs like Laufer have standing. Can she bring this complaint? Has she been injured? Is it an injury that applies to her? So forth and so on. The court decides not to decide the question because after briefing began, Laufer voluntarily dismissed. I would answer the important and recurring question, which we all agree has the authority to do so, and I would conclude they lack standing. So Justice Thomas wants to answer the question, and he sort of agrees with me. Well, I don't know if I actually agree with him on the question that she lacks standing. The ADA seems to be, or the regulations seem to be written more broadly. They say basically you have to give information to anyone who asks. So it's not clear that you necessarily need a patron to be a patron or intended patron of the hotel, given the exact wording of the regulation. But of course, I'm open to hear his comments on this. Title III of the Americans with Disability Act prohibits discrimination on the basis of disability in full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodation of any place of public accommodation, such as a hotel. Title III defines discrimination to include failure to make reasonable modifications, which is a fairly important work. But this you can no longer merely get out of this because there's some de minimis cost, which used to be the law. The Supreme Court took that case like 2 years ago and said that's not enough. If it's merely de minimis, if it's way too expensive, we can still look at the financials to see if it's overly burdensome. But the mere fact it's costing you some monies isn't enough anymore. We have to look at it in a more factually intensive way. Okay. To enforce the ADA, Title III creates a private cause of action that permits any person who is subject to discrimination on the basis of disability to sue. Only injunctive relief and attorney's fees are available to private litigants. The Attorney General, however, may obtain damages or assess civil penalties. The Department of Justice has promulgated regulations, known as the reservation rule, to aid in the implementation of the ADA. So the statute doesn't exactly specifically speak to this issue, but that's okay because, as always, agencies can have regulations as long as they're compliant with the law, and see Chevron for that. We're going to interpret that as being binding legal authority because apparently that's how we roll somehow. The rule requires hotels to identify and describe accessible features in enough detail to reasonably permit individuals with disabilities to access independently whether a given hotel or guest room meets his or her needs. The rule also applies to reservations made through a third party. Laufer, who is wheelchair-bound, is self-described tester of the compliance with the reservation rule. From our home in Florida, Laufer scours the internet for hotel websites that do not contain the required accessibility information. When she finds a deficient website, she sues the hotel. She often offers to sell immediately for $10,000 in attorney's fees and corrective action. This is how she makes her money. In the past 5 years, she's filed over 600 lawsuits against the hotels, which is quite a lot of money. $6 million, in fact. In this case, Laufer visits the website of a bed and breakfast located in Maine, the Coast Village Inn. She filed suit against Coast Village owner, the hotels, although strictly speaking, at the time, they were owned by somebody else, but that's fine. For failing to provide sufficient information. She also contended that 13 third-party booking websites, such as Expedia, failed to provide the accessibility information for Coast Village Inn. Laufer initially alleged that she was planning to visit Coast Village Inn as part of a cross-country trip, but that was some lies and bullshit. The district court concluded that Laufer lacked standing and dismissed. The First Circuit reversed, relying primarily on this court's holding in Haven Realty, that a tester had standing to sue under the Fair Housing Act. Now, I will take note that there is potentially a language difference in the Fair Housing Act. The Fair Housing Act's language speaks to a prospective tenant, right? Not just anybody. And my understanding was the ADA language spoke more to everybody. So there's a potential difference there. By the way, if you're curious about that case, Haven's Realty from 1982, a excuse me, a civil rights group, as memory serves, sent both a black guy and a white guy to the same apartment complex, like on the same day, asking whether or not they had any rooms available for rent. They told the black guy no, they told the white guy yes. And thus you have the discrimination. So that's what happened in that case, and yeah, that's not legal. Thank you. When the hotel petitioned for certiorari, she agreed. She highlighted that the circuits were split as to standing and argued clarity from the court is barely needed. After we grant certiorari and set the case for argument, she filed notice in the district court of voluntarily dismissal of her claim with prejudice. And even though the hotels had already filed briefs, they requested we dismiss the case as moot. We denied the request at the time, but agreed to consider it later. This case has been fully briefed and the court has heard the merits. Today, the majority opts to resolve the case on mootness. We can and should address the question on which we grant certiorari. I agree they can, and I agree they should, regardless of what the answer is. I would not dismiss the case as moot. There's no question we have authority to address standing. Standing and mootness are both jurisdictional doctrines that flow from Article 3, and there's no mandatory sequencing of orders. They can consider them in any order they want. These, the majority and Laufer self-acknowledge we have discretion to determine the issues in our own time. We should first address standing rather than resolve the case on mootness. As an analytical matter, where they have standing the day she filed suit is logically antecedent to whether she mooted her case. She can't moot a case for which she doesn't have standing in the first place, so that makes sense. More importantly, whether she's standing to bring the rule claims is a recurring question, which it certainly seems to be. As the majority explains, Laufer has single-handedly generated a circuit split, which is pretty notable. Pretty notable. One person has generated a circuit split 6 ways. How nice. And of course, she's far from the only tester. Beyond answering the question for our colleagues at the Court of Appeals and District Courts, we should answer the question for the hotel, which has spent significant time and resources briefing a question that will now go unanswered. That too. Once more, the circumstances strongly suggest strategic behavior. After the case was well underway, Laufer filed a notice with the district court voluntarily dismissing her claim with prejudice, ostensibly because another court sanctioned one of her attorneys for misconduct, but that attorney had nothing in question to do with the case before us, which of course is fairly typical. That's fairly typical. It is common to have a different attorney at each stage of the proceedings because they require different levels of specialization. Or specialization in different things, I should say. Not different levels, that's a little bit unfair. Specialization in different things. So your trial counsel is probably not your appellate counsel, is probably not your Supreme Court counsel, and that was the case here. All right. Laufer's logic is that she dismissed her claim and they should no longer address whether she is standing, because an attorney, in an entirely different case, engaged in misconduct. It is entirely different. It does not her case. An unrelated attorney's conduct does nothing to change the analysis required to determine standing. Facts. Laufer admits as much, arguing only alleged misconduct could distract from the merits of the ADA claim and everything she sought to achieve. Why? Because it's not your attorney in this case. I would not reward Laufer's transparent tactic for evading review. Although the majority leaves the door open to exercise review in the future, we needlessly invite litigants to follow the path to manipulate our docket. I tend to agree with Thomas into that. I tend to agree in that. All right. Turning to the question presented, Laufer lacks standing to bring the ADA claims. Article 3 of the Constitution extends judicial power to all cases and controversies. Standing doctrine serves to limit judicial power to cases and controversies of the sort traditionally amendable to and resolved by the judicial process. In doing so, standing preserves separation of powers by preventing the judiciary entanglement in disputes that are political. As I previously explained, the mere filing of a complaint in federal court does not a case or controversy make. Correct. Just because you file it doesn't make it legal because people file some bullshit. Our judicial power does not extend to every violation of the Constitution which may possibly take place, but rather to a case in law and equity, which under a right of such law is asserted in a case of justice. Right, the Supreme Court doesn't take free-floating issues. They don't take free-floating issues. They only take issues in cases that are live and go through the normal course. To have standing, a plaintiff must assert a violation of rights. Yeah. After all, the province of the court is solely to decide the rights of individuals. It is not to address a claim only of harm to him and every citizen's interest in proper application of the law. Yeah, general standing is not a thing, except in freedom of religion cases as it applies to government funding. Okay. Laufer lacks standing because her claim does not assert a violation of right under the ADA, much less a violation of a right. Her claim alleges that the hotel violated the ADA by failing to include on its website accessibility information that the rule requires. Yet the ADA provides that no individual shall be discriminated on the basis of disability in full and equal enjoyment of services of any place of public accommodation. In other words, the ADA prohibits only discrimination based on disability. It does not create a right of information. So it looks like Justice Thomas is going to distinguish on the statute, as opposed to the reading of the code adopted by the administrative agency, because of course the administrative agency can only do what the code authorizes and can't do any more than that. I hope this is yet more tea leaves that Chevron is coming to an end. I would really, really like Chevron to come to an end. That would be great. Please make it happen. Laufer's ADA claim is thus different from the tester's claim under the Fair Housing Act the court addressed in Havens Realty. In contrast to the ADA, the Fair Housing Act explicitly prohibits representing to any person because of race that any dwelling is not available for inspection, sale, or rental when such a dwelling is in fact available. Accordingly, when Haven Realty told a black tester no apartments were available, but told a white tester it was, the court found that black tester had standing. The court explained the statute created a legal right to truthful information, so there's that. So I misunderstood or I misquoted the Fair Housing Act. So fair enough. So the Fair Housing Act contains a requirement to give fair information to anybody, and the ADA is written slightly differently. So I had it reversed when I talked about it earlier. So I apologize for that. Havens Realty has no bearing on this standing as a tester, which provides no such statutory right. So fair. So I had it backwards. The Fair Housing Act says anyone who asks. The ADA says disabled people. So there you go. Laufer points to the rule, alleging it creates entitlement to accessibility information. But even assuming a regulation could and did create such a right, they assert no violation of her own rights with regards to the information. Laufer doesn't even harbor someday intentions of traveling to Maine to visit the village. Her lack of intent to visit the hotel or even book a room elsewhere in Maine eviscerates any connection of her purported legal interest in availability of information. Okay, that's one way of going about it. So yeah, it provides a notice to give information, but you weren't really a real customer. You weren't really trying to find it, so not so much for you. You only found it because you were trolling. So I can get behind that decision. More important pedestrian terms by use of Justice Scalia, what is it to you? The hotel's failure to provide accessibility on its website is nothing to her because she's just claimed any intent. I'm comfortable with that. I'm comfortable with that rationale. That works for me. Rather than assert a violation of her own rights, she casts herself in the role of a private attorney general, which isn't really a thing the federal law really allows for very much at all. It's very little exceptions. She describes herself as an advocate on behalf of both herself and other similarly situated disabled persons. She admits as a tester, she visits hotel online sites to ascertain whether they're in compliance with the ADA. As a public official will do, she even monitors these hotel websites she's found lacking. She uses a system to track each of the hundreds of hotels she sued. Once the case is settled, she marks the date when defendants agreed to fix this website. On that date, she revisits the website to ensure compliance. She has a working business model, and she tracks it with some appropriate diligence. Laufer sues not to enforce a specific legal right for a violation who works a direct harm, but to force hotels to comply with the rule, vindicating the public interest as a function of Congress and the chief executive, and by extension, of course, the Attorney General. However, not plaintiff presence, private plaintiffs. The President is tasked with the duty to take care of the laws be faithfully executed, and the executive branch has discretion to choose whether and how to enforce the law. As Judge Newsom has explained, testers exercise a sort of proactive enforcement discretion properly reserved to the executive branch, with none of the corresponding accountability. That makes sense to my mind. This case, would Kirk consider putting a synopsis in the main case? I always provide a synopsis at the beginning of my streams for exactly that reason. This case exemplifies danger. An official could have informed the hotels that its website failed to comply with the rule, and the hotels could have updated its website to explain it had no rooms. Laufer, however, chose to enforce each technical violation of the ADA she could uncover with a lawsuit. Because she is a private plaintiff, no discretion was required or exercised. And of course, Laufer has been willing to forego her suits if a hotel pays up, even though the ADA provides for no damages for private litigants. Laufer's aggressive efforts to personally impose penalties for violations of the rule go far beyond that Congress envisioned for plaintiffs under the ADA. Without a violation of her own rights, she lacks standing to sue hotels under the ADA. Ensuring and monitoring compliance with the law is a function of government, not private persons who do not assert violations of their own. Standing ensures courts decide disputes over violations of a person's rights, not compliance with the law in the abstract. Because she's not asserted a violation of rights of her own, she has no standing to bring her claims. The court should not avoid reason exclusion. I would vacate and remand. I'm comfortable with that decision. That makes sense to me. So I'd be more inclined to join Justice Thomas on this one. Let's see what else we got. We have a concurring judgment from Justice Jackson. I agree with the court that the case is moot and should be resolved on that basis. But the court goes further, ordering vacator of the judgment under Munsingware. In my view, where mootness ends an appeal, the question of what to do with the lower court's judgment, if anything, raises a separate issue that must be addressed separately. Mootness and vacator are distinct concepts. Start with mootness. The doctrine of mootness stems from Article 3 of the Constitution, which permits federal courts to adjudicate only cases and controversies. Simply stated, a case is moot when the issues presented are no longer live or the parties lack a legal cognizable interest. If a case becomes moot, the existence of the case or controversy is at an end and therefore no basis for the exercise of judicial power. Mootness thus only requires dismissal. Barring some other justification, we can't go further. Perhaps, but as the majority rightly points out, the Supreme Court has already dealt with this issue in a case, Munsingware, and they're not going to revisit it now. Vacator is a different anomaly. Vacator is a remedy that erases a judgment. Here the court invokes the so-called Munsingware vacator, a specter of vacator we sometimes apply to judgment in civil cases that become moot while on their way here or pending our decision. The precise origins of the vacator, both as a general matter and in Munsingware form, are uncertain. In fact, some has described the power of the court to vacate a judgment as shrouded in ancient lore and mystery. Cute. It seems plausible that our authority to vacate a lower court's judgment under Munsingware arises from our supervisory appellate powers, which possibly, to make such disposition as the case may require. All agree, however, that vacator extends to provide courts with power to protect all rights and do justice. The Munsingware remedy, like its vacator, can develop from an equitable tradition. Of course, the Supreme Court can decide matters of equity. It's in the Constitution. As an equitable remedy, vacator is not granted as a matter of course. Instead, precisely because vacator is rooted in equity, the decision whether to vacate turns on conditions and circumstances of a particular case. Per historical tradition, a court is asked to exercise equitable authority to vacate judgment, must determine essence whether it's most consents to justice. Because mootness and vacator involve different legal analysis, I think the court should address them separately. So she's not a fan of Munsingware, and I appreciate her analysis. This is reasoned analysis. I appreciate where she's coming from. But the rest of the court doesn't want to reevaluate that right now, so that's, where we're at. For one thing, automatic vacator plainly flouts the requirement of individualized, circumstance-driven fairness evaluation, which I've explained is the hallmark of equity. The essence of equity has been power to do equity and mold each decree to the necessities of the case. Vacator is an extraordinary exercise of power, and such cannot simply be a one-size-fits-all solution. I appreciate her analysis as to this. This makes logical sense to me. I don't know whether or not I would sign on to this or not, but what she's saying resonates with me. I'd have to go reread Munsingware and think about it for a while, but I appreciate her analysis. It makes logical sense. Second, and perhaps more fundamentally, automatic vacator is flatly inconsistent with our common law tradition of case-by-case adjudication, which assumes decrees are valuable and should not be cast aside lightly. Our legal system rests not only on the holdings of the court, but also on the reasoned decisions of duly authorized lower courts judge. Jurists presiding over the case at every level have a duty to say what the law is. Fair. And maybe she wants to overturn Chevron because she's quoting Madison. Maybe. Please. That mootness can sometimes leave the parties unable to appeal and does not bear on any continuing validity of the lower court opinion. We do not consider a court's judgment to be less binding on the parties simply because there's not an appeal. Fair. Appeal or not, lower court rulings are still the law. With respect to the case at hand, for sure. And it's not as if a decision rendered by a lower court is less final, unless and until it receives the imprimatur of the court. Breach. Indeed, many lower court determinations are not even appealed as a matter of law. True. Our legal system regards those decisions as pronouncement of law, nevertheless. While district court decisions are informative by their nature, they're never precedential. So, but still they're binding us to the parties, that's for damn sure. In other words, even if a party cannot appeal, or opts not to, lower court judgments are binding and presumptively valid. And the lack of appeal on its own does not suffice to rebut the presumption. Any suggestion on the contrary misunderstands the scope of authority all federal judges pursuant to Article 3 and disrespects the time and talent of jurists who have undertaken efforts to assess the matter. I appreciate that as well. Not always the validity of a lower court's judgment cast into doubt as a result of the case's subsequent mootness, nor is the validity cast in doubt because of the mootness. We do not erase past precedent just because those cases cease to be live, litigated matters. Yeah, I mean, that's true, right? I mean, Mussingware is a precedent, and that case has long since been over, so those judgments don't disappear just because the case is over. Facts. Every federal case fades to black at some point, yet in our common law case-by-case adjudications, those rulings the judges have issued remain good law. Yep. There is no particular reason to assume a decision later mooted is any less valid as precedent than any other opinion, citing the Court of Appeals for the C Circuit. Why then does the possibility of nullifying a lower court's judgment by ordering Mussingware vacator exist? I submit it serves a specific equitable function to address any unjust circumstances or unfairness that might stem from the inability to appeal a prior lower court decision, notwithstanding its presumptive validity. And just as Mussingware itself, the party seeking relief from the status quo of the appeal judgment bears the burden of establishing equitable entitlement to this extraordinary remedy. Thus, in my view, sound vacator arguments must be rooted in fairness. Likewise, I believe a court Mussingware determination should involve a particularized assessment. So she disagrees with Mussingware. She doesn't think it should be automatic. So, fair. Her critiques are fair. Her reasons for critiquing are fair. They're reasoned. I understand this. It is, of course, impossible to catalog all potential circumstances that might justify vacator. That's for sure true, especially if you're dealing case by case. It's essentially impossible because every case is a little unique. As a general matter, I believe when a party who claims equitable entitlement to vacator must explain what harm, other than having to accept the law, flows from the inability to appeal. The procedural history of Mussingware provides an example of the kind of harm that might warrant vacator. Another stems from the fact the courts must also take account of the public interest when making the vacator determination, which raises broader fairness concerns, such as ordinary operation of the federal judicial system. For that reason, I think the court's sensitivity to the hotel's concerns about litigations manipulating this court's jurisdiction could be a relevant vacator determination, and likewise reflect in our prior observation that it would be strange to permit a plaintiff to obtain a favorable judgment, take voluntary action that moots the dispute, and then retain the benefit of the judgment. Facts, we don't like people manipulating the courts. We take a dim view to that. I appreciate her analysis. It suffices for now to say that flexibility, rather than rigidity, has distinguished a court's equitable power and potential for exercising it. Still, it bears repeating, the reason for the vacator remedy must be more than mere disagreement with the decision. Every lower court Every lower court loser would, of course, prefer the lower court opinion not exist. But in each and every case in our adversarial system, one side loses and generally must accept the outcome. Pretty much. Of course, sometimes both sides lose a little bit, which is also fun. To me, such principles about the nature of vacator remedy, the design of our common law, and the scope of appellate authority best inform the court and other courts of appeal should proceed while addressing the Munsingware motion. Mindful that vacator of a lower court judgment is extraordinary remedy, which is kind of true in equity, kind of implicitly, and fully cognizant of the dangers of uprooting presumptively valid legal precedent, contributions to common law that belong to us all when we're governed by the rule of law, not just the parties in the case, preach. We should carefully evaluate the purported need for vacator in terms of the harm. And in the absence of harm, we should conclude the public interest is better served. I like this analysis. I like this analysis very much. She's making sense. She's spitting some facts and some law that like Uncivil understands and appreciates. Right? Again, if I were going to do this for real, if I were going to decide to sign on with her judgment, I'd of course have to go back to Munsingware and reread it and of course think about it a little bit more critically. But she's giving me reason to rethink it and reconsider it, which is always good. So she's spinning some stuff. Uncivil law understands. Uncivil law understands these things. These are some reasonable points, Justice Jackson. Okay. Yeah. Tony, if you can figure out how to make the instructions for Twitch, linking the Amazon and subscribing as short as possible, I could actually potentially create a trigger for it, or so that you could just like type asterisk or exclamation mark something that would provide instructions so you don't have to do it every time. So if you can find a way to like shorten it down to, like 140 characters or less, that'd be nice. So that'd be great. All right. I'm actually not sure what the limit on a post is, but shorter is better. All right. As I'm said, aware the party who's deprived of the opportunity to appeal to mootness might feel that loss acutely because they can't appeal because it's been moot. So yeah. It might even experience the thwarting of its chance to obtain a reversal on appeal as a grave injustice or on par with other fairness-based justices. I also recognize the court has previously expressed sympathy for that view. Yeah, but I disagree. There's nothing inherently unequitable about not being able to pursue an appeal. Not sure if I agree with that as it relates to, especially the party inviting mootness. I'm not sure I agree with that part. So that's where, again, like I'd have to reread it and think about it. Yeah, it's limited to 200 characters, be that as it may. If we could still make it shorter, if we could make it less, that would be great. Thanks. See what you can do. See how you can cram it into fewer characters. Thank you. Okay. To reiterate the basic bottom line, the lack of jurisdictions that prevents an appeal and says circumstances that relate to whether the court's judgment should be permitted to stand are entirely distinct. The lower court issued its ruling while the case was alive, and so rendered that ruling, its precedent, presumptively correct and valuable to the legal community as a whole. That observation is what done is done, and thus, starting point for ascertaining a response to mootness beyond mere dismissal of appeal. It is true the losing party would ordinarily have the right to challenge the lower court's decision by pursuing appeal, but that right is not absolute or inviolate. Wanted appeals can sometimes not proceed for a host of reasons, and in such instances, the losing party is struck, and she cites a footnote. Our court might not decide to grant a would-be petitioner's request for certiorari. Well, I'm not sure that counts. Or after granting review, we might dismiss the petition. Well, I'm not sure that counts either, because the Supreme Court is, of course, a court of discretionary review, so I'm not sure that example counts. There was a case alive, though. There was a case alive at the time they granted cert. It was alive at the time they granted cert, yes. To be sure, in the instance case, there is another wrinkle. We not only granted the petition for cert, but we also heard oral argument related to the merits of the claim that the lower court judgment was erroneous. Thus, the hotel had better opportunity than most to achieve the requested reversal of the Court of Appeals' unfavorable decision. but this court demonstrate interest in reviewing the challenge to respond to the mootness legal action does not add anything to the fairness equation. Now that the appeal has been mooted, which transforms it into non-binding precedent, the response to moot legal action does not add anything to the equation. And the hotel is in no better position than the multitude of other litigants who suffered defeat in the Court of Appeals. Well, they're in a slightly better position because the Court of Appeals decision has been mooted or vacated, so it's no longer precedent, so that's nice. Yeah. Okay, that's a pretty good one, Tony. If that's the best you can do, then put it in the YouTube mod chat, would you, on Discord, and we'll refine it to perfection, and then we'll create a trigger. That'll be great. Excellent. All right. Also, incidentally, if my mods need any other triggers that currently don't exist, you can also let me know. We can discuss that in mod chat. That'd be great. The parties in the case have not provided equitable basis for vacator, nor has the majority described any beyond reference to the court's past practice and citation to Munsingware. For the reasons explained, I would ordinarily not agree to the imposition of vacator that was not fully discussed, much less established, but I recognize the court's vacator ruling is consistent with our established practice of the Court of Appeals when that occurs. I concur on the basis of precedent, despite my views of practice, because the dismissal is the sort of unilateral action that would previously deemed adequate for vacator. So she disagrees with Munsingware, at least in part, which I appreciate, and I also appreciate Justice Thomas's analysis along the line. So that's where that sits. So she has agreed not to be a tester anymore, so she can sit on her cool $6 million or so. She wants to retire from the game, I guess. And others can operate in her stead under the precedence of various circuits, and maybe someday we'll see this again. Who knows? So yeah. David asks, isn't the result of a judgment there's no standing, that there was no case or controversy? Not necessarily. There could be lack of standing for another reason. There could be lack of standing because, well, standing is three things. You have to have been harmed. Let me see if I get this right. You have to have been harmed in some way. The harm has caused damage, and there has to be something the court can do about it. So those are the three things you need for standing. And so there has to be a controversy with respect to you. You've been hurt, and the court can fix it. So that's what you're looking for. And a classic example where the court can't fix it is political questions. You know, for example, if Congress, passed a law that said there's now a 90% income tax, and you're sued, like, that's too much. The court can't fix it because, it's political how much the tax should be. So that'd be an example. Her attorney is in legal trouble, but not with respect to this case. And the Supreme Court counsel is, of course, different, as you would expect. So, yeah. So that's where we're sitting. Yeah. Any other questions before I wrap up the chat? I appreciate the 200 of you who have been here and 661 views we've gotten so far. Supreme Court opinions not as popular as some of our other coverage as of late, but that's okay. We try to give comprehensive legal analysis of all kinds. It was crookedness with one of her relatives. Well, be that as it may, she's not her relative. So, just like juror is not juror one's wife, as we've taken some pains to discuss recently. So, how's Tom standing private enforcement analysis with Texas abortion law? Well, as a matter of state law, there's a difference on a matter of state law versus federal law. So the three-part test I just quoted you is the requirements in federal courts. Different states have different requirements when it comes to standing. And with the repeal of Roe, it seems like there isn't any obvious federal interest in the Texas case now. Although there might be some residual one there and some due process land somewhere. So my tentative answer is yes, there's sufficient standing as a matter of state law. And if a person ultimately gets adverse judgment against them at the highest level of Texas's appeal, assuming there is a federal issue, that would give them standing because they've been harmed by a invalid decision under the U.S. Constitution. So yes, both ways, I guess. The legislature saying that a person has standing kind of does it. It would be difficult to. It would be a very odd law that Congress could pass that explicitly grants someone standing that doesn't actually give standing. That would be a very weird situation. I'm open for the possibility, but of course, we always presume laws are constitutional, so I wouldn't bet in favor of such a scenario. Okay, everyone, I guess I will sign off since I seem to have answered all the questions. I hope you've enjoyed this analysis of this Supreme Court decision. I think the Supreme Court missed an opportunity to resolve the standing question. I think Justice Thomas's analysis makes sense to me, especially the precise words of the statute. And even if you want to get past that with the precise words of the statute, that despite the words of the statute, she doesn't have standing because she's merely a troll, and that doesn't count. Which I know, because that's just merely a public harm. So the statute, even if you could somehow read it that way, shouldn't be read that way. You should read against it because that might be an unconstitutional way to read it. So you read against that, which makes sense. So I'm down for Justice Thomas's concurrence. Kind of wish it had been the majority decision so we could clarify this issue, but it wasn't. So, we'll live for another day. All right. I've been on civil law. Until later, my friends, I hope all is well. Cheers, my friends. Until later, and goodbye.